Yes, Ms.
Thank you, Commissioners. Advocate Johnson, before we broke for lunch, we're trying to understand what investigations took place after your authorization for a Section 28(1)A investigation on the 30th of May. And you indicated you wanted to consult the records to respond to that.
Thank you, Chair. Council, I did contact the office. I've asked them to put it together, and they're in the process of just putting together a little document that will state between 6 December and 20 May and 20 May and 27 June. I've asked them to please do that for us.
Why 20 May?
So for the date of the authorized
30th May.
30th of May. Yes.
Now, I'm just interested from the 30th of May.
Yes.
Because we do have the docket 54206 2025. And I'm saying on my reading of that docket, I can't find any document relating to investigations post the 30th of May.
I take your word for it.
Oh. Well, that's my reading of it, and I accept that I may very well be wrong. We know that that docket is numbered 542/6/2025. And we know that from the cover sheet of Mr. Adams's A1 statement of 6th of January. Would you like us to cast our eye there? That would be...
Are we in file 3?
File 3, page 68. File 3, page 681. Now, if we look at that, we see at the top, it's got a cast number there of 542/06. And I checked with Colonel Padiache, and I think many other police officers that have appeared. I'm reliably informed that the middle number 06 relates to the month in which the case was opened.
That is correct.
So I take it the case was opened in June 2025.
Yes, the docket would have been registered June 2025.
And that is a day after you authorized an investigation, at the earliest, the 1st of June. It doesn't give us the actual date, but best case scenario is that it's the 1st of June 2025 when a docket is opened.
I take that.
And your authorization to investigate is the 30th of May.
Correct.
So they're already deciding to open a criminal case before proper investigations in terms of Section 28(1). Do you see that? Could have been later in the month of June.
But I do see it's in the month of June.
It's in the month of June.
Yes, ma'am.
And remember, we are chasing the 26th of June, which is the arrest date. We're trying to understand what happened when, post the 30th of May. Staying on that page, at the bottom of that page is a date. 2025-01-06, bottom left corner.
I see that.
Now, Colonel Padiache explained that this was a preamble, this preamble to the statement and the statement were obtained on the 6th of January 2025.
Okay.
That's his explanation, because I couldn't understand why the docket has got a June date, as we have determined, but the statement seems to be taken in January. He had an explanation for that they open the docket, or they take the statement in terms of this document and will subsequently open an official criminal docket later. But that's the explanation as I understood it. And I accept it. I've got nothing to countenance it. So my issue really is, on the 6th of June 2025, already we are into criminal investigation mode. And this is very early during what ought to have been the 2813 preliminary investigation process to help you determine whether to institute a formal investigation in terms of Section 28(1)(a). Do you accept
I'm
that?
with you. I accept it.
And that is where then my challenge lies with this 2813 preliminary investigation and the authorization for the actual investigation. And I suggest that, I'll say the investigators in this case, abuse the Section 2813 preliminary investigation to conduct a full-blown investigation before you so authorize them. They've gone so far as to obtain documents from SAPS to prepare an A1 statement in January.
As I indicated earlier, Council, the 2813, while it is a preliminary investigation, does allow you to subpoena documents. It does allow you to engage with witnesses, and it does allow you to do some form of investigation.
Yes.
Yes.
But at this point, while they are doing that, remember, we are trying to show up the Section 27 affidavit. SAPS shouldn't be involved. This is now an IDEC process. You approach the referee to perhaps substantiate if that's what's required. Why is SAPS getting involved at this juncture when you are still trying to address the shortcomings in the Section 27 affidavit?
The shortcomings, as I understand it, can only be addressed by us obtaining the necessary documentation to either support or to dispute the claims made by Mr. Adams. It is, as he said, the Section 27 doesn't have supporting documentation.
Yes.
He makes his averments. In order to determine whether or not these become a reasonable suspicion, we need to rely on the allegations he's making, and where would we find the evidence of those allegations?
Yes.
And it is for that reason, Council, that one is able to subpoena documents. And it is so that the documents sought were invariably at SAPS.
No, this document wasn't at SAPS. It was commissioned by Chief Perumal on the 6th of January.
I'm saying the documents that we would seek in order to support.
Oh.
Yes, sorry.
No, you are ahead
Sorry.
of me. I'm still on this statement.
My
Why
apologies.
is SAPS involved in this statement, which is seeking to obtain clarification on matters raised in the Section 27 referral? Why is it being registered at SAPS already when you have not authorized an investigation?
I think
Why
I'm a
is
bit-
IDEC at Brooklyn Police Station opening a case in January 2025?
If I look at the case number, Commissioner Khumalo, 542 of 6/2025 is a case being opened in June 2025. It is not January of 2025. That's how the case number reads. I understand the conundrum then of what is this date here at the bottom that shows a 6th January.
And also look at the name of the station. Don't just look at the date. Look at the
Correct.
name of the station and the form itself. That's a subs form. That's not an inquiry from IDEC.
No. So when you register a docket, we register it on the SAPS CARES system, and we have to fulfill the requirements of the CARES system, which is to fill out that form. That's the only way I understand you are able to.
That's exactly the question. Why are you registering a docket on the 6th of January 2025 when you are still at the preliminary investigation stage?
I understand your question. I'm begging to differ only because of the CARES number. The CARES number determines, and I'm not trying to be controversial, the CARES number has always been what determines when the case is registered on CARES. So 542 of 6/2025 says that a case was registered at Brooklyn in the month of June 2025. I sit with the same conundrum as all of you do. What is this 6 January 2025? If we're talking about when was the docket registered, it would work on the CARES number. That is my understanding of it, and that is how it has always worked.
Or it means the docket was registered without a case number and a case number was added later on. Because looking at these two documents together, the cover sheet which says preamble to the statement on 681, and then the particulars of the offense, that's the affidavit, that's also January 2025. They go together. And all of that would have been done in January 2025. Yes, the case number could have been added later in June, but the substance of the question is, why is IDEC involving SAPS in January 2025 when it is still at the preliminary investigation stage? So the substance of the question does not change.
And I understand, and I cannot answer why that happened. It shouldn't happen. It should have been when the CARES number was registered. So what I'm trying to get to, Commissioner, is the SAPS, CARES, and any involvement within the CARES system ought to have been in the month of June 2025, not this date of January. I can't explain the date of January.
Because my expectation would have been that you would have an IPID inquiry number, and you would start with that and only get to the SAPS documents in June.
That is correct.
Thank you, Commissioner. Then just to
Sorry,
complete
can I
yes.
just say that my difficulty with how you explain that a full-blown, what turns out to be a full-blown investigation happens on the back of a decision for a preliminary investigation. My difficulty with that is that full-blown investigation is used to show up an incompetent referral, Section 27, if that's what happened. Because what you had is, you had this wholly inadequate Section 27 affidavit, which on its terms does not make a case that triggers your jurisdiction. You then authorize, as you say you're entitled to do, or you have the power to do, you then authorize a preliminary investigation, and that's where you collect all of this evidence, but you use that to show up a poor referral. So again, that's not the purpose of your Section 2813 preliminary investigation. It's not to assist what should have been kicked out or not accepted by you because it didn't trigger your jurisdiction. It's not to use that process, because if that's what you are doing, then you are using your Section 2813 process for an unintended purpose. Its purpose is not to fix Mr. Adams's poor Section 27.
Correct.
It cannot be. So if your explanation is correct, that's exactly what happened, then we are again in that territory where, in fact, the Section 2813 was used as a pretext to make up a case that Mr. Adams should have pleaded or should have stated in his founding affidavit, and so your people would have acted improperly. They did that which the law doesn't allow to use that process for, which is the point that Mr. Law was making, that you authorize a preliminary investigation, but that preliminary investigation, in fact, is used to conduct a full-blown investigation. Your explanation of it proves exactly that they use the pretext of your authorization to assist, make a case that places Mr. Adams's complaint into your jurisdiction when in fact from the get-go it didn't fall within your jurisdiction, at least not in Section 27. Do you accept that, if that's what happened?
I accept it.
Okay, thank you.
Thank you, Commissioners. You recall Commissioner Khumalo referred you to the national instruction. I think it's 11 of 2017. Did I understand you to suggest that you were not aware of it? Or perhaps I misheard?
I did indicate that I hadn't seen the instruction.
Okay.
Yes.
Can we go to file 8? And in particular, to page 3255. For the record, that's CJC 389. 3255. That should be your, what you call your prosecution note addressed to the
DPP?
To the DPP. If we go to 3257, I see at paragraphs 9 and 10, is that not the instruction note that you referenced there? The same instruction note that Commissioner Khumalo referred you to?
That is correct.
So you do know that instruction note?
I didn't see the instruction. I know of this instruction because I got this from the briefing from the team in order to prepare this memorandum.
No, please say that again.
So when I prepared the prosecution memo, it is as a result of a briefing I get from the team. So the charges against the suspects were presented to me by the team. And so part of the charges and part of the case is as a result of the feedback I got from the team. So I would have got from the prosecution a memo, a draft memo, upon which I look at it and then compile my referral to the DPP. But I didn't see the actual instruction as Commissioner Khumalo had shown it to me today. I didn't look at that instruction.
So the upshot of what you are saying is that in your prosecution memo, you referred to documents you had not seen.
I did not see this document, no. It is as a result of a briefing by the team and a memo that I would have got.
I accept that there was a briefing. I'm saying the long and short of it is that in this memo, you referred to documents you had not seen.
Correct, sir.
So you did not even know that the section 9 you are quoting, in fact, says what you say in your memo. Because if you had not seen it, you could not satisfy yourself that it says what you have quoted in paragraph 11.
Yes, that's correct. It would have been as a result of the briefing, not of me seeing the
Yes.
document.
So you did not satisfy yourself that what you are quoting in your paragraph 11 is in fact what the instruction says.
No, I relied on my prosecuting team and my investigators.
And then you proceed at paragraph 12 to state, same document, evidence collected proves that accused 1 to 6 contravene the provisions of the above quoted section to benefit accused 7 without just or reasonable cause.
Yes. And that I would have got from the briefing. It's a briefing that they would have given me and indicated, Chair and Commissioners, how each one is allegedly implicated.
What if they are wrong? You are triggering a prosecution. What if they are wholly wrong? Your investigators and whoever it is you rely on.
My prosecutors and investigators.
What if they are wholly wrong? Because nowhere in this document do you say, I come to understand or I'm made to understand. You're making definitive assertions here, suggesting that you are familiar with the prescripts, you are familiar with the evidence that has been collected, and you confirm that accused 1 to 6 have contravened the prescript. How is that not misleading, perhaps, to the DPP?
No, because I did get a briefing and I have no reason to believe that the prosecutors would have briefed me incorrectly.
But you are making assertions to the DPP on matters you know nothing about.
No, I
And
know.
that's by your hand.
Sorry, I interrupted you.
I was saying, and this is by your hand. So the DPP reads that as she should to understand that the head of IDEC has satisfied herself, because that's what triggers her response at 3255.
Correct. And I'm saying that I satisfied myself from the briefing that I received from my team.
Okay. Now, I would like us to turn to your statement, your October 25 statement. And in particular, I would like us to have regard to page 8, paragraph 24. Now, this is your statement to this commission.
Yes.
You stated 24, following upon receipts of the dockets, the information therein was analyzed. Thereafter, an investigation was undertaken. Is that a Section 28 investigation or 2313 investigation?
At that time, following upon receipt of the docket, that would have been the 13.
The 13.
Yes, ma'am.
Then you say the investigation unearthed sufficient evidence, 1, to conclude that there was reasonable and probable cause for the prosecution, and Roman 2, formulation of the charges against Lieutenant General Khumalo. So the preliminary investigation pointed to prosecution bypassing a formal investigation. That can only be the case.
In the first part, following upon receipt of the dockets, the information contained therein was analyzed. Thereafter, an investigation was undertaken, that is the 2813. The investigation unearthed sufficient evidence. That would seem to be exactly what it says in that paragraph.
The 2813 investigation.
Yes. Because I'm unable to read into it a 28-1.
Yes. Now, I would like us to move to paragraph 25, but the last sentence thereof. No, perhaps the fourth line. I may indicate that there was a series of matters referred to IDEC in terms of Section 27 by one Mr. Adams. When the whole picture is presented, they include the following. 25.1. The manipulation of recruitment processes and appointment of persons without suitable qualifications into senior strategic posts in the Criminal Intelligence Unit. Who are these persons? And as you think about that, to what posts were they appointed?
In the one that comes to mind, it is the appointment of Brigadier Mokwele.
Brigadier.
Yes.
Yeah. Who else? Because you're talking again
Appointment
about
of persons. Those matters are still under investigation.
And which persons are these? Remember, this is from Mr. Adams's Section 27 referral. So they must arise from that referral.
remember that, not remember. At the time this affidavit is deposed to, it is now October 2025.
Yes.
By then, the 28-1 has been authorized and investigations have continued, not just in that matter, but in other matters that arise from the complaint.
Okay.
So I'm not restricted, this is not restricted to the 27 of Adams. I may indicate there was a series of matters referred to IDAC in terms of Section 27 by one Mr.
Yes.
Adams. But then when the whole picture is presented, that is, I read it to mean, I meant when the whole investigation is presented, the manipulation of recruitment processes and appointment of persons without suitable qualifications into senior strategic posts in the supposed to be in the crime intelligence unit. The one that comes to mind is the matter that is currently in court. And I know that there are other investigations.
But that picture can only emerge from the Section 27 referral. You say so as much. See, there were a series of matters referred to in the Section 27 by one Mr. Adams, when the whole picture is presented.
Yes.
So that picture emerges from that referral.
That's how I
understand it as well.
I know how you understand it. I say that's what I understand is that we get the 27 referral from Adams, but when you look at the whole picture,
Yes.
This is what that picture shows, and that would be the picture that comes out of the Section 28 investigation.
So you are suggesting that there is further information post the authorization for a Section 28 that points to unauthorized or manipulation of processes to appoint other persons other than Brigadier Mkwele.
That is correct.
Under what number? I take it won't be this particular case number, so would it be an inquiry number?
It would have to be an inquiry number, which which I must provide to you.
Now that you have brought this matter to the Commission, will you please disclose all those inquiry files and their respective numbers?
Yes.
Where the commissioners will determine which persons are these you're talking about?
Correct.
Okay.
And then bearing in mind, no, it is fine. I keep in mind what Commissioner Khumalo said about the standing orders and how matters should be approached. So I will give you the reference numbers for those. But what is very clear is arising out of these engagements, one would have to relook the matters, relook them with that factual and legal positions that were put to IDAC and at least put to myself.
Yes.
I cannot go back. Having had these engagements, commissioners, the fact that there are investigations in the office does not mean that they shouldn't be relooked at. However, bear in mind that I'm not vested with oversight of those. What I should responsibly do is put together a report for the Office of the National Director so that whoever's reviewing any and all of those matters does take these discussions into consideration. It would be irresponsible if I do not do that, having accepted what was put to me by the commissioners and the manner in which we engaged.
I know Commissioner Khumalo wants to pose a question, but before he does so, may I correct you? I understood you to say you're not vested with oversight over those investigations. That's got to be wrong. You are the head.
Yes, may I explain?
Absolutely.
On the 19th of June, I approached the National Director and I did ask, I hope Advocate Maga, you have now provided, because I think Commissioner Baloy did indicate that we hear what you say, but where's the proof? On the 19th of June, I approached the National Director on my own, and I indicated to him that it might be best for the interests of IDAC and the NPA that I be removed from the oversight of these matters. The basis for that, commissioners and council, was that on the day prior, there was the media briefing by General Nhlanhla Mkhwanazi. What that brought to bear for myself is that for as long as I am in these matters, the matters themselves are not seen. The focus becomes the ID, or the focus becomes Andrea Johnson. That is not in the public interest. That is not in the interest of justice. I had that open conversation with the National Director on the 19th. The National Director asked me if I am sure, and I said yes, because the matters, as well as the NPA and IDEC, have to come first.
Then, if I understand, the power of oversight is bestowed upon you by the statute.
That is
So you're
correct.
suggesting, pursuant to a request you made, you were stripped of that power insofar as matters relating to crime intelligence are concerned. Is that what you're saying? And to whom has the power then shifted?
If I can just go here, because I know that Commissioner Baloy, you did ask a question about, how that could have happened. And when I looked, after having had the conversation, if I may, conversation with the National Director, he thanked me for my pragmatic approach and he agreed. He then indicated, as he publicly did afterwards, these matters will now go under review. And that is the power of the National Director. I report to the National Director. But if it is in the interest of the NPA, as the National Director under Section 22, 1 of the NPA Act, the National Director, may I read it into the... The
Yes,
National Director, as the head of the prosecuting authority, shall have authority over the exercising of all the powers and performance of all the duties and functions conferred or imposed on or assigned to any member of the prosecuting authority by the Constitution, this Act, and any other law. And then may review a decision to prosecute or not to prosecute after consulting the relevant director and after taking representations within the specified period by the National Director of the accused person, complainant, and any other party, person or party whom the National Director considers to be relevant. It is on the basis of his powers to ensure the performance of and duties and functions conferred or imposed upon myself, as an example of someone employed in the NPA. I make the request. He accedes to the request. He understands that it is in the best interests of those matters, public interest, in the interest of justice. And when he agrees, it's not just you, I agree that the team doesn't report to you on these matters anymore. He says, I remove them. They now fall under the reporting structure of the Deputy National Director of Public Prosecutions, who heads the National Prosecuting Service, Advocate Bell, and as well as the fact that the National Director has appointed, Advocate Marga might help me with the correct wording, I think there is an independent review panel that has been put together to consider not just one matter, but all the matters for processes of fairness and transparency.
As I read Section 22, that's the one you just read out to us, that relates to prosecutorial decisions.
Yes.
Not investigation decisions.
They are.
And let me just finish. Earlier, you indicated that in the course of investigations post-May 2025, after your authorization, you have come across a number of instances where manipulation and of recruitment processes occurred, resulting in unsuitable people being appointed to senior strategic posts. Those are the investigation files we have called for to try and determine who these are.
Yes.
I don't understand Section 22 to suggest the NDPP would have authority over those investigations. It's the prosecutorial decision that he is
The
reviewing.
NDPP has the right to review or have to be reviewed the Lushaba matter, which is in court, the Mokwele matter, which is in court, and the matter for which warrants of arrest had already been obtained for Generals Khumalo and Madondo. Those
that
are
is
prosecution matters.
That is because in those cases, a decision was made to prosecute.
That is correct.
So it's a prosecutorial decision that
Yes.
he's reviewing.
That is
but
correct.
That's not our investigations that are currently within IDEC.
Yes, the investigations that are currently within IDEC, as I said, would have to now be relooked
By you.
by myself.
Okay.
Keeping in mind what was said during the engagements, especially the ones on the appointments. I might have to look as well, commissioners, at in detail the, if there are, and I assume there would be, standing orders with regards to vetting and make a determination on those matters and submit them through to the office of the NDPP.
Standing order sounds very police-like. You meant national instructions, I think.
Sorry, national instructions. Sorry.
Can I just ask the question? Before this Mokwele matter, or apart from this Mokwele matter, has IDEC investigated any employment, appointment, recruitment issues ever?
Commissioner Balawi, no, not that I'm aware of, no.
Thank you.
I really hope Commissioner Khumalo hasn't forgotten his questions. I know. Took a bit of a detour. My apologies.
It's not a detour because we're still dealing with 25.1, which
Yes.
is where you were. Advocate Johnson, 25.1 of your original statement to the commission. You say the manipulation of recruitment processes, appointment of persons without suitable qualifications. I think because you had not seen the national instruction, we can accept that you don't know what the processes are because they are set out in that national instruction.
I accept
fair?
that.
Is that fair?
That is fair.
Yes. Now, let's look at the suitable qualification. What suitable qualification do you say Ms. Mokwele did not have when she was appointed to this role? What is that suitable qualification that you say she did not have?
I would have to have sight of the, I can't tell you off my head. I'd have to have sight of the advert.
Go to
Sorry.
file 2, page 178.
Sorry.
Can you please flight it?
And because Commissioner Khumalo seems to know all the pages.
No, it's file 2, page 178.
I am there.
Yes.
I
So
would have to
those
read
are,
it.
if you look at item 3.2.
Yes,
on
I have
that
gone
page.
through that one.
So that is the position in question.
Yes.
Do you see that in bullet 1, it requires that the person must have at least a 3-year degree or diploma?
In policing, public administration.
Yes. And then it
management
says
law,
in
etc.
policing or public administration or criminology or intelligence or electrical or mechanical engineering. Do you see that? Or did IDEC stop at policing and say,
No, I'm reading as you. Yes. And I don't know her qualifications. But the fact that you point me to that means they must be there.
Stop there, Advocate Johnson. You don't know her qualifications.
I know she has, it was called megatronics.
Do you know what her qualifications are?
Not all her qualifications, no.
So why do you make a statement under oath to say she's not suitable for this position if you don't know what her qualifications are? Why do you make a statement to this commission to say the big picture will show that she doesn't have qualifications? Can I ask that they be flighted so that we can look at them? Can we go to 270 on the same file? Are you there?
Yes.
So that's a degree in engineering, industrial engineering. Do you see that?
I see that.
So already she meets the qualification. Now go to the next page on 271.
I see that.
Are you there?
I am there.
Now that's a diploma in mecha, not mega, mechatronics. Now, what is the relevance of that? That is the core description of this role. If you go back to the advert on 176, you will see that the core functions, what crime intelligence was looking for, is exactly this qualification. Because the description of the role tells you that they want somebody who's qualified in mechanics and electronics and all of those. Do you see those?
I see that,
Yes.
Commissioner.
Now, from 270, I don't want to show her matric certificate.
No,
It's not
yes.
fair to Ms. Mukwele, but it's on 272. Please don't flight it. It's quite clear that this is somebody who is very bright. I must say this to you. Before I saw these files, the picture painted in my head was that crime intelligence appointed a receptionist from BMW. That's the picture I had in my head. Until I saw these files, then it became clear to me that this person is not just qualified, but her qualification exceeds the requirements. Now, from 273, which we can flight, it's about 12 certificates that I've counted. Because one of the requirements was that you must be familiar with computers, you must be familiar with finance, you must be familiar with how the public service works. So there's a series of them. I counted about 12. Cybersecurity being one of them on page 281. There's about 12. We don't have to look at all 12 of them, otherwise
I'm
it
just
will
quickly
take
browsing.
the whole day. Now, having seen all of this, do you stand by what is stated in 25.1 of your affidavit that he does not have the suitable qualifications?
So she has must have at least 3 years, an applicable postgraduate qualification, relevant in middle management, learning programs, must have a minimum period of 3 years appropriate managerial experience in the field of the post. For me, the only one, I'm not disputing what you're asking me. I just want
Are
to
you saying she's not bilingual and she doesn't have a driver's license?
No, no.
Because those are some
No.
of the requirements.
No.
Do you want to dispute those?
No, must have
So
a minimum.
what do you say? What is the qualification that you say in 25.1 of your affidavit that she doesn't have? What is
Must have
that
a minimum
qualification?
period of 3 years appropriate managerial experience in the field of the post.
Is that a qualification?
No.
Experience is a qualification.
No, it was just a requirement.
Yes. Now,
Yes.
your
In terms of-
affidavit says she does not have the
In
qualifications.
terms of the documents that I now have sight of, that is incorrect.
It is incorrect what is stated in your
It is
affidavit.
incorrect.
She does have the qualifications.
She does have the qualification.
Now, what your investigators have done in their affidavit to the court, they have said Ms. Mokwele does not have 7 years senior management experience, and therefore she does not qualify. Now, show me on 179
It doesn't say so.
where it says you need 7 years senior management experience.
It does not say so.
And
It does.
that is the basis for IDEC targeting this female person and subjecting her to criminal proceedings and humiliation. What the advert says is that you must have appropriate management experience. Where does one find a definition of appropriate management experience? Where does one find it? It's in the national instruction. It's in the definition section of the national instruction. And this is what the national instruction says. You must have experience above the level of a supervisor. That's all that was required. If Ms. Mokwele met those requirements, then she complied with the minimum requirements according to the advert. In her application for this position, she lists all those. She goes further and she says, I'm studying for my MBA. Are you aware of that?
No, I haven't gone through her
Did
affidavit.
you see her application for this job?
No.
Now, if you have not seen her application for this job, how can you make a recommendation, as you did in your prosecution memo, that she must be charged with fraud and this many other things? What fraud has she committed? According to the investigation, let's not go to what the court will decide.
Yes.
I don't want to get into what the charge sheet says.
Yes.
We limit ourselves to investigation that leads to arrests and charges. What
Correct.
fraud has Ms. Mokwele committed that justifies you recommending to the DPP that she must be charged with fraud and state capture and all of those things?
Again, I relied on the briefing from my team, and it's going to go back to what counsel had asked me, that I trusted them implicitly. I now see that the facts as I may have received them then, and I'd have to go back and look at it,
And-
were incorrect.
And they misled the court in many respects because the impression they created was that the panel just did as it pleases. I want to take you to 3 documents that illustrate that above the panel, there was senior HR and people at general level who supervised the work of the panel. We're going to start on page 200, same file.
I am there, Commissioner.
Are you there?
I am there.
I'm going to challenge you before we go to. You described Ms. Mokwele's appointment as a token appointment. It's an unfair statement to make, having not seen her CV, having not seen her qualifications. Can you please, in this commission, withdraw the statement that her appointment is a token appointment? It is an insulting thing to say.
I would have to go further than to withdraw. I would have to apologize that that statement was made.
Because it's one thing to say an appointment is irregular.
Yes.
It's quite another to say it's a token appointment.
Yes. I base it on what I was given, but I accept, having gone through this file, that the word unsuitable
Yes.
is unsuitable.
Yes.
And that the word token is wholly inappropriate.
Sorry to interrupt you. Let's look at page 200. What page 200 and 201 reflect is that there was a proposal that a panel be constituted. And that proposal or recommendation had to be approved by the Deputy National Commissioner Crime Detection. But also if you go to 201, you will see that Acting National Commissioner Support Services, Lieutenant General Nkua,
Yes.
approved it.
Correct.
So IDEC must accept that somebody higher than General Khumalo approved the appointment of this panel. Okay, now let's go to the shortlisting itself and the shortlisted candidates on page 222. Sorry, it starts on 221.
I am there, Commissioner.
So what you have here is a request for approval. Once candidates have been shortlisted, there's a request for approval. And if you look at the paragraph 2, the second bullet point, are you there?
I am there.
Do you see that is the post section head, technical support services?
Correct.
Now, do you see that somebody higher than the panel actually went through the list of shortlisted candidates and examined whether each of them qualified to go through the interviews? Because in respect of that one candidate, they make it clear that here the requirements are not met and therefore this person cannot be shortlisted. Do you see that? Maybe take your time and just read paragraph 2.1.
I see that one.
And then 2.2.
I see that one.
And you can assume that the next page, paragraph 2.3 to paragraph 4,
Will
are
have-
along the same lines. But look at paragraph 4 before we go to 223.
Sorry, paragraph 4.
Paragraph 4 on 222. It emphasizes the need to comply with the relevance policy prescripts. Do you see that?
I see that.
So SAPS looks at these things at a level above the panel. There is somebody who's reviewing the work of the panel to satisfy themselves that the panel is complying with the prescripts. And then you go to 223. Do you see that the approval is granted?
Sorry, 223.
223, Lieutenant General Nkua,
Yes.
Human Resource Management, grants the approval. And you need to read that with paragraph 2. So you must go back to 221. I'm going to read it into the record. Approval is hereby granted for the selection panels to proceed with the assessment of the shortlisted candidates for the post, which with due regard to the content of paragraphs below. Do you see that?
I see that.
So within SAPS, there was all that approval. And then we must now, I suppose, go to the national instruction. I won't read the paragraphs into the record. I will just draw your attention to the relevant paragraphs that one must look at when one assesses whether Ms. Mukwele or the panel have done anything wrong.
Sorry, Commissioner, I just need to find my document.
Help is on its way. Somebody's there to help you.
I'm told Commissioner Baloyi took it back.
Yes, Commissioner had given me a copy.
No, just go to file 3. We had
File-
located, I think, it's page 706.
Let's give it to Mudia.
Huh?
File
It's
3,
okay, Commissioner, but
page 706.
we have found it. Let us not dispossess you. Thank you.
Advocate Johnson, I'm going to go through this very quickly because,
Yes.
so just look at clause 2 or section 2. I don't know whether they call them clauses or sections. Clause 2 of the national instruction.
If Commissioner would rather just give me the page number at the top, is that the 707?
That's correct, that would be 707.
Thank you. I am there.
Maybe for now, then just look at B in clause 2.
Done?
Do you see that this is what I was referring you to?
Yes.
And then I'm not going to read them, just
Yes.
clause 6, I'm just highlighting them to you. I'm not going to deal with them. Clause 6,
I see that.
clause 7 deals with the selection process.
I am there.
And then clause 12 deals with the recommendation by the panel.
I see that, Commissioner.
And then let me highlight this 13 subclause 2.
I saw that.
Do you see that it says the Deputy National Commissioner, Divisional Commissioner, Regional Commissioner, Provincial Commissioner concerned must certify that the process took place in accordance with this national instruction?
I see that.
So at a level above the panel, you have 4 people who are not part of the panel who must certify that the process
Has been followed.
has been followed. Now, if those 4 people have certified that in this specific case a process has followed, don't you think it was necessary for IDEC to go ask them, why did you certify? On what basis? What was the reason? Because they would know the national instruction better than IDEC. Not so.
Correct.
Advocate Silo, I think for now I will stop here.
Thank you, Commissioner.
Can I just raise my concern about your 25.1, the affidavit? Even allowing for your explanation that you didn't look at the documents, so you never saw this advert. You relied on a briefing from your investigators and had no reason to doubt them. Even allowing for that. The difficulty that I have with your 25.1 is that at the time that you prepare this affidavit,
Commissioner.
is that at the time that you prepare the affidavit for the commission, you now have the full set of documents. You have the docket, you as you prepare, and I must again assume that you prepped for this. You didn't rely on briefings when you came here. You looked at the documents, what they say, how did we get to those decisions, what were we relying on, because you know that you're going to be asked questions about this. And if that's what you did, I have a difficulty that you still represent what you state in 25.1 when your documents, all your documents that you requested were collected by your investigators are now all before you. You are coming to the commission and you still repeat the statement in 25.1, which as Commissioner Khumalo has shown you, it's not supported by the documents that are in your own dockets. And it leads me to one of two possibilities, that as you come to the commission, you come prepared to continue a narrative that is not based on any evidence that was before you, properly placed before you, and underlined properly placed before you, for purposes of your decision then, but also for purposes of your preparation here. Notwithstanding that, you're prepared to continue that narrative. The alternative is that you did not do the necessary preparation to be able to give us full, comprehensive answers. Otherwise, you would not have said to us in that paragraph that she was appointed as a result of manipulation of processes, and everywhere else in your affidavits where you continue that line. Which one is it of the two? And maybe there's a third. You can give a third.
Yes. In my preparation, and in hindsight, I should have corrected it. I just didn't correct it. I knew that I would be asked and be given an opportunity. In hindsight, Commissioner, in the manner in which the question is posed, the correct thing would have been rather remove these paragraphs and or insert a different view.
And when you came to testify and prepared for it, did you have any difficulty with the idea that you will come here and you will not defend the indefensible now that you have the benefit of preparing and having had the evidence of for example, Colonel Pareachi, very importantly. And I think I expect that on the back of listening to Colonel Pareachi's evidence, you went about to do your own investigation. You asked questions based on whatever you were following. You asked questions to the right people. Did you have, and I asked the question because it does bother me that you have said what you've said in the affidavit. Did you not get to a point where you thought, well, maybe some of the things that we did should not have happened? And when I go to the commission, I will fairly concede as much.
Which is what I've done now in this process.
Yes.
I'm not defending my process.
Yes. Now I'm talking about when you were preparing to come here, because you're making concessions because as you're being probed, it's not as if you volunteered it. You happily read that paragraph and everything that it represents, everywhere that you speak about recruitment processes having been manipulated to appoint somebody as part of a capture process, which you're still going to tell us about, as part of the capture of crime intelligence for money laundering to happen. You have repeated that. Your affidavits speak to that. Nothing more, nothing outside of that, or nothing different from that. You continuing the narrative that is in the charge sheet, that is in Colonel Pareachi's many affidavits, that was in his evidence. So I ask of you, and I ask of you because you are the head of institution, I accept that in some cases you will rely on your people to brief you, right? Instead of reading documents, because you have a lot to other cases to look at. And in some cases, you may well be excused, not in all cases. But when you're now coming to testify here. And we had a similar discussion about what happened in the ad hoc committee where things were put to you and you said, well, I didn't remember it, but we know there's a record of it. Here again, there's been this repetition of a narrative. Until you are probed, you make the concession, and yet some of the things, in my view, should not even have required you to be probed. You should have come in and said to us, I've looked at this, and either you did not look at this stuff in preparation for coming here, or in my view, you looked at it, but you were going to continue the narrative because that's already what you have said on paper and in other fora. And that's why you stick to that version, because you cannot change it. I struggle with that. And I struggle with that, as I say, because not only because you're head of institution, but also you're a lawyer with obligations to forum like ours, with a full understanding of what an oath means and the consequence of saying things under oath that you had no reasonable basis to believe. I ask in that way, and it is a matter of concern for me that you have continued this way, and concessions have had to be forced out of you, forced in quotes, but had to be extracted from you without you volunteering them up front. I don't know if you want to say anything to that.
No, I hear you.
You understand my concern?
I understand what you said, yes.
Thank you. Sorry, Missile.
Thank you, Commissioner Baloyi. I don't know if the commissioners have anything else to say, to engage the witness on in regard to the paragraph 25.1, because I would be moving on. But if there are questions, I think...
We will come back to the appointment issue, but paragraph 25 for now, because it simply said manipulation of process and suitable qualifications. The part of the qualifications
as dealt with,
and
yes.
the part of the recruitment process we've covered.
Okay.
We may come back to...
I accept that. Thank you, Commissioner. We're staying with your statement to the Commission, Advocate Johnson, and we're now at 25.2. Remember, this is the picture that you say emerges from Mr. Adams's referral, and by referral, I'll use the expanded definition, which is the referral, perhaps what was gleaned from the dockets and from the subsequent A1 statement of 6 January. So I take them collectively. You say there was a bypassing of vetting processes, which amongst others manifested itself in a failure to apply for and get top secret clearance where required. Who failed to apply for and get top clearances were required? Is that Mrs. Mukwele still?
No.
Who is this?
That is the other matter that is under review. That is the matter of General Madondo.
Does this arise from the Section 27? I didn't read the Section 27 to ever reference persons within CI failing to obtain clearance certificates.
No, this arises out of the investigations that were conducted.
Yeah, so
After the 28th.
So when you suggest that it arises from Mr. Adams's Section 27 referral, that's at head misleading, isn't it?
No, I did explain earlier, and I know we don't agree, that I said I may indicate that there were a series of matters referred to IDEC in terms of Section 27 by one Mr. Adams. When the whole picture is presented, that is the investigations, these are the things that they present, and they were then into different investigations.
So then I should assume, if it doesn't arise from the Section 27 referral, I should assume in the course of the preliminary investigation, because that's all we have.
Yes.
What you stated, 25.2, became apparent. Correct?
Correct.
I would assume that would require a Section 28 authorization to investigate. It is outside the Section 27 referral.
Correct.
Did you authorize investigation into the vetting and top security clearances for anyone within CI? And if so, when did you authorize?
I think that the authorization was one authorization.
Is it part of the file you gave this morning?
It should be.
Okay, what we received starts from this morning, what we're looking at starts from file 83280. We can skip that 3280 and go to 3282. That's the one authorization we dealt with. And this was, that had the annexure of 12 names. File 8.
There must be a...
So they started 3282. The next should follow at 3285. This is CJC 390. And then we had 3288. But 3288 is for authorizations in terms of section 28 sub 1. And if we pause at 3288, so that's a section 28 authorization. And this one at 1.1 section suggests that the persons listed in paragraph 1.2 of that document have committed some corrupt act in contravention of the Prevention and Combating of Corrupt Activities Act. I'm reading 1.1 and 1.2 together.
Yes.
And this, as I read it, sounds like, if you look at 2.1 summary of facts, this is at page 3289, sounds like that it's in respect of the, I'll call it the Mukwele matter, and for lack of a better reference. The persons you have cited at paragraph 2.1, if memory serves me well, either served on the panel, correct?
Yes.
Or had involvement in the eventual appointment of Mrs. Mukwele. At 2.3, you quote the SMS, and once again, you speak of the employment of the employee and what it is subject to. Then, beyond that, at 3291, you then deal with the legislative mandate. So this is about the appointment of Mrs. Mukwele, that authorization.
Correct.
Okay, then we can move on to the next authorization. It's at 3299. And this one, it's dated 30th of May as well. This is for fraud at 3299, for fraud and any offense involving dishonesty. Statutory offenses there, once again, in PRECA. And it's in relation to activities within the South African Police Service and Crime Intelligence. And you say here, you have decided to conduct a preparatory investigation. Judging by the date, I don't know if this is a different preparatory investigation or you actually meant a full-blown Section 28 investigation. Is that the correction? You remember when Commissioner Baloyi referred you to a similar?
That was the correction.
Is a correction, so we should cancel preparatory. Okay. And in this instance, here you then authorize, you then provide an annexure of the persons who should be investigated. But that's for fraud and offenses concerning involving dishonesty. And then if you look at 3302,
Sorry, 33.
of the same authorization, it's common law offenses of dishonesty, and then statutory offenses, including but not limited to contravention of corruption and gratification, and contravention of the provisions of, once again, PRECA. And if you look at 3303, once again, this is dated May the 30th. If you go to 3304, it's the next document. That's the designation, I guess, in relation to the Section 28 investigation you have just authorized from page 3299. Am I correct? And you recall that what we are looking for is authorization to investigate members of the CI as regards their top security clearances and their failure to apply for such. And then by the time you get to 3307, those are the two documents provided this morning on your per request. And this is the application for investigation in terms of Section 2813. This one takes us back. And the next one, that's Exhibit 390.5. The next one is Exhibit 391. And that is, those are the two letters that you addressed to General Sintumule, and at 3314 to General Khumalo, Major General Khumalo Detective Services, requesting the dockets. There is no authorization regarding the investigation into the vetting and issue of top secret clearances for the various other members of crime intelligence.
I see that that is not here.
Yes. So will you be in a position to obtain that? It's one thing to have a Section 28 authorization. It's another to understand, for the Commission to understand the basis of your exercise of that power, which would mean the investigation file must be provided as well. Otherwise, the Commission is not in a position to interrogate whether or not you exercised your power based on any concrete fact or evidence. And that becomes particularly important, I should point out to you, because in February already, and if you go to file 3, page 936. And you suggest that the authorization into these matters regarding security clearances for other officers within crime intelligence would have arisen after their preliminary investigations. So after you granted your authorizations, and that would have been in May 30th, on 30th May 2025. You recall that?
I recall that.
So now at file 3, page 936 is a summons issued on the 6th of February 2025. And if you go to 937, it states under details of the matter or other information, this investigation pertains to manipulation of security vetting processes, which resulted in the unlawful issuing of security clearances in favor of personnel within the division, crime intelligence of the South African South African Police Service. This is in February. So it's not informed by any investigation. At this juncture, the assumption was that it's informed by the Section 27. Now you have just testified that no, the issue of vetting and security clearances in respect of the those persons listed at 938 arose after the preliminary investigation and not from the referral itself.
Yes.
That's what you explained. So now, are you able to explain why it is your investigators in February already? Remember, you are still to authorize a Section 28 investigation on the 30th of May. In February or 2025, if you go to 938, why has it triggered a full-blown investigation and issuing a Section 28 summons to obtain the vetting, the security clearances and vetting files for the officers listed in there? At page 938.
See that at 936.
Yes.
It says that the investigation was authorized by the investigating director in terms of Section 2813 of the NPA Act into allegations of fraud and corruption.
But then it can't be, because you've just said that, that we know that 2813 we have arises from Mr. Adams's referral.
Yes, and the subsequent engagement with Mr. Adams.
Yes, and his A1 statement of one page of January. You just indicated that that referral does not speak to the top security clearances of other persons within crime intelligence. You said that it was informed by investigations that IDEC conducted on your authority.
On the 4 dockets that what I did say earlier was that there were the 4 dockets. They retook statements on each of those dockets, and the prosecutor grouped those dockets in terms of the categories of offenses. So the information that we would have had arose out of the 27 with the dockets and the Section 2813 approval that was granted. There wasn't one docket dealing with one matter. So the statement that we did view of Mr. Adams, I agree, relates to one matter. I did say that there were other dockets on which they took additional statements. Or amplified statements in order, sorry.
But we agreed earlier that you agree with the conclusions drawn by, I don't know if, let me say, Lieutenant General Kamani, that the information contained in the same dockets is scanty and too vague to formulate charges against any suspect. You said you agreed with that conclusion.
I agree with his conclusion there.
Yeah.
May I proceed?
Please, absolutely.
Sorry. However, IDEC took additional statements because the statements in the original dockets by Adams were exactly what General Kamane says. They were flimsy. So they took additional statements. That is exactly how I understood their engagement with Adams in January of 2025. That on each of the matters, Council, they took additional statements.
Okay. This would be additional statements from Mr. Adams.
From Mr. Adams, ma'am.
Where he then mentions these people specifically as implicated in the unlawful issuing of clearance, in the vetting, in the manipulation of vetting processes, and unlawful issuing of security clearances.
That is what should be in there, yes.
Thank you.
May I add then to the list of documents we request, can we get each and every such statement by Mr. Adams you say it was in January 2025?
That is when the engagement took place.
Yes, and you said that I think he deposed to a number of statements.
Yes, that is what the investigators indicate, that they took statements
Then,
for each docket.
We're requesting all those statements.
Mr. Maga is,
No. I don't want to leave the responsibility with somebody else. I want you and I to agree.
I agree with you. I'm
Thank you.
just looking at Mr. Maga to just note while we are engaging. Thank you.
Okay, so then if we go back to your statement 25.3. At 25.3, you remember that you said this is what the investigations unearthed. I take the preliminary investigations because those are the only on record. The appointment of persons not suitably qualified and or experienced as a form of gratification for their collusion later in the looting of state funds, e.g. the purchase of properties. Now let's break it down. The appointment of persons not suitably qualified and or experienced. Is it safe to assume that the A1 statements you are bringing, presumably by tomorrow, would address the issue of the appointment of these unnamed persons? They have to be in those A1 statements.
That have to be.
They would have to be. The second leg is as a form of gratification. Please explain that. I take it because we know the Section 27 doesn't tell us. Those statements are going to demonstrate that a gratification was paid, I'm not sure in which direction, to somebody or other.
Can I interrupt and take a step back?
Absolutely, Commissioner.
If the person you are referring to in 25.3 is suitably qualified, so we're turning it around. If that person is suitably qualified, then their appointment cannot amount to gratification.
Correct.
You accept that?
I accept that.
So if we accept that Ms. Mukwele met the requirements that we put up, then her appointment cannot be gratification at that level only.
Absolutely.
Yes.
And if you'd allow me to maybe finish the thought is, as I've indicated, I would have to go back into those matters that are still under investigation and to determine whether or not those aspects raised are then still relevant. Do they find relevance? Because if, in the manner in which we have engaged, if those aspects no longer find relevance in those matters would have to be closed and dispensed with.
Because for one to get to the point where one says their appointment amounts to gratification, one must start at, did they qualify for the position?
We have to start where you started.
Because if they qualified, then they were properly appointed and their appointment cannot amount to gratification.
That is correct. Yes. And so both, sorry, Council. Sorry. And so both the vetting processes, those allegations of the vetting processes, as well as the allegations of the recruitment and gratification for the matters still under investigation have to be properly revisited.
I think the vetting issue in respect of Ms. Mukwele, we can put that to bed because Colonel Padiaki accepted that the way CI did it, the way the panel did it, disadvantaged Ms. Mukwele. It did not benefit her because the requirement said she must subject herself to vetting 6 months after the appointment. So the fact that they were doing it before the interview was in fact disadvantaging her, not benefiting her. I think with Colonel Padiaki, we settled on that and he accepted.
Yes, I accept that. I'm saying with all other, the averment of persons not suitably qualified and or experienced, and or with regards to vetting, if they still find place in those other investigations not yet completed, those would have to be looked at as a matter of urgency and dealt with.
I don't want to force you to concede that because the other people the process of their vetting was different.
Yes.
With Brigadier Mukwele, the requirements were clear that it must happen 6 months, within 6 months after. So the other people that you referred to in your summons, I'm not there yet, so I don't want to force you to concede that. just yet.
Thank you, Commissioner. It's not a concession. It is a matter of saying, I have heard the argument and I should reapply my mind, given all of the discussions that were raised.
Your response to Commissioner Khumalo that if a candidate meets the requirement, then there couldn't be gratification. I don't know that that is correct in your present case, that kind of answer, because gratification is a quid for a quo.
Yes.
So the way you have constructed the charges against Ms. Mukwele is that she was given the position so that she can do something. So she's been rewarded with a position to do something. And that's something you have described it as capture of crime intelligence. You have described it as such. So it seems to me that on the case that you have, it really doesn't matter if she, whether she met the requirements or not. Your case is this is a precca offense. They have appointed this person so that they can siphon off funds. That's Mr. Adams's complaint, which you have agreed with in the formulation of the charge. So and I don't expect you to do the same thing that Colonel Parachi did, which is, well, we don't know what the offense in the future will, whether she will commit it or not. But the charge itself would have required you at day one to say, and maybe you do have that. I'm not getting into the merits of whether you have a winnable case or not. I'm speaking at the starting point is you formulate a charge, and if the charge is giving someone employment, that's one form of gratification. It's employment in return for something. That provision in PRECA doesn't say someone who's not qualified.
Correct.
It doesn't. So she may well be qualified, and yet she gets appointed precisely so that she can assist to achieve certain ends. So your concession that you are easily making now, that, well, if it is a qualifying person, there could not be an offense of gratification. The offense is not just the appointment.
Yes.
The offense is you get appointed because you're going to give something.
Yes.
In return. So your answer, you have to amend.
Yes.
Your answer to Commissioner Khumalo.
The answer talks to the suitability in terms of the appointments and whether or not the vetting processes were met. The additional issue, if in fact related to all and not just to Mukwele, would have to be looked at differently. The appointments of persons not suitably qualified and or experienced as a form of gratification for their collusion later on. I have to see what that investigation says. I cannot tell you that there is in fact evidence that there is collusion. The concession I make is that with regards to suitability, the standing instructions, and the vetting process, those are the matters that I would look at. And
No, I'm not raising with you, certainly not raising the vetting issue. I'm raising a narrow issue with you, which is your answer, your concession to Commissioner Khumalo suggests that you accept that because if it is found that she met the requirements, then we were wrong to claim that this is a PRECA offense, which is a gratification offense. I don't remember the exact wording of that provision. I'm saying your answer to the extent that you're saying, well, if she did meet the requirements, then we are wrong. I'm paraphrasing. I'm not saying that's what you said. If your answer is because she meets the requirements, or if it is found that she met the requirements, then we couldn't speak of gratification. I'm saying you are wrong, because
Yes.
that's not what that offense is about. That offense is you will prove in court that her appointment, it so happened that you say she's not qualified, and you say she's appointed even though she's not qualified. But in court, you will show that this appointment, qualified or not qualified,
Notwithstanding is a gratification.
it's a gratification for what she's going to do. You understand the point
Yes.
I'm making?
No,
you
that
agree
does
with
not fall away.
You agree with my construction?
I can't agree with your construction. That is not that's not a concession. It is to look at the suitability in terms of the advert, the requirements, the standing orders.
Okay, thank you.
If there are, in terms of the other investigations, and I'm not saying there are, in terms of the other investigations, I need to go and check.
Okay, thank you.
I do need to go and check.
Thank you, Mr.
Just be careful. I was limiting myself only to your paragraph 25.3.
Yes.
I was not going to the offense in section 3 of PRECA, which is what Commissioner Baloyi is engaging you on.
Yes.
So the answers to both our questions may be different.
I understand, and I didn't assume
Yes.
that you went beyond
Yes,
just the
I deliberately
suitability.
avoided going to the charges. I was just sticking to your statement.
Yes, I accept that.
Thank you, commissioners, and thank you, Advocate Johnson. For my edification, 25.3, does it apply to Mrs. Mukwele? Or do you think it could potentially exclude her because she might be suitably qualified? How do I read it? How do you suggest I read it?
So we have agreed, Council, that she is suitably qualified.
So therefore, the remainder of 25.3 doesn't apply to her.
She's suitably qualified and experienced. The appointment of persons not suitably qualified and or experienced as a form of gratification for that doesn't exclude that part of why she was appointed, even though she's suitably qualified. Yes.
So then she is not out of the woods yet, because if you are to concede that she could potentially be suitably qualified and experienced, her appointment in and of itself is gratification for her collusion later in the looting of state funds.
That is correct, yes.
What in the investigation leads you to believe that in the future she will collude in the looting of state funds? Something in that investigation must have pointed you out to this. What could it potentially be?
So the information that we had at the time was that in the process, she would have been part of a process where monies would have been taken from the secret funds in order to purchase properties, and that her placement there would have assisted that process. That was the contention or the allegation.
As a mechatronics, whatever, I'm trying to understand. I hear what you are saying is restating what is contained in 25.3. You're not giving me a basis for that conclusion. You're already concluding that she will be involved by virtue of occupying that position. And I want to understand what in the investigation leads you, by you, I mean IDEC, to conclude that you give her that job, she's in the Secret Service Fund. And therefore she will be looting state funds to pay. She'll be colluding, correct myself? I don't know with who with, but to loot state funds and purchase properties. What in those files should we look out for to support the conclusion that you draw, the fear that you express at 25.3?
I'll just have to be given an opportunity to go back and to look into the evidence.
No, you must have had it. For you to submit on oath, you confirmed the correctness of this statement when we started. So you must have an idea, and I suggest that perhaps you start sharing it with us. Might not be firmed up. When you return, you will give us the full now facts, chapter and verse. But for now, when you wrote 25.3 in relation specifically to Mrs. Mukwele, on what basis did you conclude that she was going to collude in the looting of state funds with whomsoever?
Commissioners, I ask for a moment.
Yes, please.
Are you thinking of a specific document, perhaps?
I'm just perusing.
I'm not rushing you, but.
Yes, I'm trying to peruse through the chart sheet to at least refresh my memory.
Okay, please go ahead.
I think the commissioners were giving you an opportunity. Have you located what you're looking for?
It triggers. It triggers the recollection, and I'm going to hold you to. I'll have to come back with the chapter and verse.
Okay.
I recall that when it came to where she was positioned in TSS, TSS is a covert environment with a very big budget, and the allegation was that if monies were needed, as an example for the purchase of properties, monies would be able to come out of there. And that if she was asked, because of disappointment, she would have felt the need to act. That was the projection, and that was the understanding of where.
Sorry, as to do what exactly?
Sorry. If monies are required or needed, the technical support services to which she would have been appointed has a very big budget. It is a covert environment. And I think the manner, and I'm giving you the explanation as I understand it, the manner in which funds are dealt with are not as open source as everything else. And so should the need arise for funds to be procured, that would be the environment from which funds could be accessed, for example, for the purchase of properties. That is how I recall.
Unlawfully.
That is correct.
So she would violate her duty of good faith to her employer. She would breach her contract of employment.
I think the contention, Commissioner Khumalo, if I recall correctly, was because the monies are in that environment, she could be approached to make those monies available. I don't know what would be presented to her for her to make those monies available, but that is where the funds are for her to make available.
But if she's doing that as part of her job, how does that rise to gratification and unlawful conduct? Because what you are saying, that would apply to any person who occupies that role. If they are required to provide money, provided that they are complying with the prescripts and they are doing that correctly, that's not a criminal offense.
No, it
They are
isn't.
simply doing their job.
Yes. If she was approached for access of the TSS funds, knowing that whatever that motivation was, she should not approve that funding.
Yes, but how
That
do you leap to the conclusion that she would loot state funds? Because that's what your 25.3 says. If she's approving a request and she's doing it in accordance with the prescripts, there's nothing wrong with that.
Not if she's doing it in accordance with
Yes.
the prescripts.
So what is the basis of your assumption that she would have done it in an unlawful manner?
That she would have been approached to make monies available under circumstances where she would not have made them available.
But how do you know that?
That was because of that environment and because of the fact that from previous matters, not in IDEC, that is how funds were looted. Out of accounts where the funds are within a covert environment. So motivations would be put in for access of that money.
You are being,
Without-
if I may come in, no. No. You are being grossly unfair to Mrs. Mukweli. Now you are attributing conduct of persons she has no knowledge of to her in the future, no how. And you are saying you accept that she may be required to access those funds in the course of execution of her job. But the impression you create here at this 25.3 is that she would do so to loot. So that apology that I think you sought to extend to her, you might as well take it back. You are seriously impugning her credibility, and we're trying to find the basis on which you say she was going to loot.
I hear you. That is not the intention. I'm trying to give an example of how I find that space. And,
You see,
sorry, if I...
oh no, you may continue if you're
No,
not done.
I think it is also wholly unfair. There's no intention to impede on her dignity. I am merely expressing or amplifying on the question. If that is how it comes out, Council, really, it is unfortunate that you think that I would, in giving an explanation, that I am intentionally impeding on her reputation and her credibility. I do apologize if that is how it comes out, but and to say that my apology, in fairness, commissioners, that I made earlier, I will not willy-nilly make an apology. The commissioners did not drag an apology out of me. I made that apology freely, and I think it should be taken from where it came. It did come freely.
You see, if there were substance in what you are saying, it would apply across the board. That is to anybody appointed to that position.
Correct.
That must be correct.
Yes.
Yeah, because you have no basis to think that she is different, and that therefore this would apply only to her. So anybody,
In that position.
if what you say is logical, anybody would also be susceptible to this impropriety.
I accept that, Chair.
Thank you.
Advocate Johnson, in June 2025. This is exactly the charge that was presented, even in the draft charge sheet to justify Ms. Mukwele's arrest. It's exactly this. So she has gone through all of this over a period of a year. It's not new that for the first time today you are making this allegation. The memos, the draft charge sheet, and all the documents, this was exactly the issue. And I say this for my part, I have no sympathy for people who loot state funds. And if there are people, whether they are generals or not, who are involved in the looting of the secret account or whatever it is, I have zero sympathy for them. But this case, as Commissioner Baloyi said yesterday, is a serious abuse of power by IDEC to target a civilian. And that's what I have a problem with. My sympathy for her is a bit different to the generals, because if they did what they did, the law must take its course. But we must draw the line where organs that are supposed to protect the public and, work for the benefit of the public are used in this manner to unfairly target civilians. That is just not right.
I understand, hence I made the apology earlier. It does not detract from the fact that there is a case for which they have now made representations. Memokwele as well.
As you said, it's not just the representations, there's also the review process.
Exactly, and yes. And so in the end, fairness and justice must prevail. So if we have made the wrong decision, then that decision will be corrected. And I'm saying that in terms of the appointment, I'm not retracting anything that I said at all.
I think my difficulty with you is if you should not think that the fact that there's a review process, there's a representation process, and therefore what you sought to do, which is to prosecute. If those decisions are reversed, then all is good. It cannot be that. Our inquiry is really about why did you make these decisions? It's not about the merits of your case. And I think we may not have fully succeeded to steer from talking to the merits, because they're intertwined with your processes, your thought processes, your decision-making process, what you evaluated, and we compare that with the legislative mandate that you have and requirements. So the fact that there will be reviews and representations that maybe do succeed is not really of our concern. Our concern is, how do you make this charge, for example, how does that allegation even arise that she is potentially guilty of a PRECA offense of gratification, but not just her? And she has been the focus of Commissioner Khumalo because she's a civilian. But any criticism that comes out of Section 25.3, in my view, applies to everyone that you have charged with an offense of gratification as defined in PRECA. And it comes from, but there are no facts alleged by Mr. Adams, the aunt, not in his Section 27, not in the affidavit, that paragraph 2 that speaks only about Ms. Mukwele's appointment. Nowhere else does he make allegations that form a reasonable basis for you to prefer a charge of gratification as defined in PRECA. That is really the issue, right? And so the inquiry to you is, why did you authorize that? Why did your investigators get to that point? Why did the prosecutor, firstly your internal prosecutor, get to that point? Why did your DPP, who said, I concur with the charges, they are good, what were they working off? So we're still at first base, before representations and before a review. Where does this all come from? Right? And on the face of it, so far, between you and Colonel Pareachi, you haven't given a satisfactory explanation, I must say. And I accept that you're still going to give us documents, the A1 statements, and maybe we'll see from there what were the facts that led to this allegation in 25.3, but also that led to the charge itself. Absent that, if you do not have documents that show the facts on which this charge or this 25.3 is founded. If you don't have any such documents, then this was an arbitrary decision not based on any facts. And because of it being an arbitrary decision, it is a use of investigative powers for ulterior purposes. If it is not explained satisfactorily for ulterior purposes, then we have to ask the question, what was the purpose? I hope you understand,
understand
what I'm saying. Yeah. So we still have to answer that question.
Correct.
And hopefully your statements will the A1 statements will put us at peace. That, well, there was a basis for that. But as matters stand, I must say, from where I'm sitting, that with everything that is before us, and until we get something else, then the exercise of the power to investigate and to charge an offense of gratification under PRECA was exercised without proper consideration, without facts placed properly, and I underline properly, placed before you for this and the prosecutor and all the people that I've listed to formulate that charge. On the face of it, the power that you have, all of you that I've listed, you exercise it for an ulterior purpose, and hopefully by the end of the evidence of the IDEC witnesses, we will find out what was the purpose. That, for me, is the real issue here. Do you have anything to say to that? Thank you. Thank you, Mr.
Thank you, Commissioner. If then we could jump to paragraph 28. You recall this paragraph when you started testifying 2 days ago. You effected changes and amendments to that paragraph. It currently reads, the picture that has emerged is that the appointment and installation of certain persons. We went through that exercise and you suggested that it's not persons, that you refer to as person, and that person is Ms. Mukwele.
Yes.
In certain positions within CI by Lieutenant General Khumalo and his co-accused persons help them strategically to access funding without following proper processes. This is because her, following your amendment, her token appointment would not stop them from their unlawful act. I think that follows on the conversation we have just had.
And that falls away.
Ma'am?
That falls away in terms of the appointment.
What falls away?
What I'm saying is the picture that has emerged is that the appointment and installation of certain persons, and we agreed that in that paragraph, it refers to Brigadier Mukwele.
Yes.
That the part of the appointment falls away, that those first two lines fall away, and that short of there being documents to prove the rest of the paragraph, then that falls away.
Okay.
But that we must have that evidence, because those assertions cannot not be based on evidence. And
So
that is what I'm saying.
The entire paragraph falls away.
Then that entire paragraph would fall away if I'm unable to find in the Adams affidavits that the investigators say they obtained per docket, Commissioner Khumalo.
It goes further. Even following IDEC's own investigation in two parts, the preliminary and the
And the-
subsequent one. There is simply no basis for what is stated in that paragraph. No factual basis.
And so I'll take it then it's a conditional deletion for now, depending on what you unearth in your investigation records.
Only the latter part.
The latter part of that paragraph. The first is already fallen
Yeah.
away. Now, you say by Lieutenant General Khumalo, he's the head of crime intelligence. He's got access to the very funds that you speak of. Why does he have to go through all these hoops to access the funds, as you suggest? As if he is outside crime intelligence. He heads it. He's responsible for that budget.
He doesn't have direct access to the budget. He has to work through the co-accused.
And they all account to him.
No, sorry.
Sorry.
I was just trying to get to the, I think he must be Lieutenant General Lushaba, or is he Major General Lushaba? But the accused General Lushaba, that is where that point relates to. So whilst General Khumalo, Lieutenant General Khumalo is the head of CI, he does not have direct access to funding. He has to work through the CFO, who is General Lushaba.
So that then, okay. The thing is, they all account to him. So then, on your theory, they must all be beholden to him, which would mean everybody in crime intelligence, because they are beholden to General Khumalo, will in the future collude, I don't know, perhaps with him or whoever, to loot state funds. That theory must apply to everyone
No.
who eventually accounts to General Khumalo.
Incorrect.
Okay,
I
correct me.
say that, and his co-accused being General Lushaba, we say that because of the first matter, which is already in court, where there was a housebreaking. His official equipment is stolen. All of it is hidden, and for a long time no action is taken. And I refer only to him. We're not talking about everybody else. That would be that would be a vile assertion to make, that everyone else would have been beholden. I say that the CFO, who still remains in his job despite his sorry, it's that time of the day. Sorry, despite his official equipment with state secret information having been stolen, it being pushed under the rug, hence the charges of the defeating, etc., that he faces.
Okay.
And him being the CFO, that is the one person. We say because of those allegations, not in isolation, Commissioner Baloy, but because of what had happened in terms of his own matter. And because he controls the funding.
So what does that have to do with this, that he strategically placed there to loot funds? I don't understand what the treatment of his case by the division, and for that matter, by General Khumalo, if that is the case, how he treated that loss of computer in that whole incident, what that has to do with the allegation that he has been placed, his installation in crime intelligence, so that he can help strategically to access funding without following, he can help General Khumalo to access funding without following proper process. I don't understand the link that you are creating between how General Khumalo treated the loss of a computer and that Lushabani, General Lushabani is in that division and in that position and will be part of this scheme to loot funds.
It is based, General, that General Lushaba, because he is the CFO and because his criminality was hidden or swept away for a long time till the investigation, that puts him in a position where we say that should General Khumalo require funds, in all likelihood, he would comply. Yes.
He will give him funds.
Yes.
Okay, you say there's that kind of arrangement between them.
That is the assertion.
Okay.
And if I may just follow up, it must be that it's General Khumalo who has covered up and swept under the carpet these issues affecting General Lushaba. It must be General Khumalo in order for General Khumalo to have that hold over him. Is that the charge that General Khumalo is facing? Is that the matter in court?
No, General Khumalo doesn't face, I speak under correction, that's not the charge he faces. He doesn't face such a charge.
Yeah, so who did the sweeping under the carpet and the covering up?
We say that at the time, when General Khumalo came to know, there was a time when this incident happened, commissioners, the CFO was actually the acting divisional commissioner. He was acting in the position that General Khumalo currently occupies. And the assertion is that when it did come to the attention of General Khumalo, he did not act for this reason. That was the way it was couched in terms of the evidence.
When you say he didn't act, you mean he did not discipline him?
I know that disciplinary action was taken, but well after the fact. I think it was after he was charged by IDEC.
So what do you mean when you say he did not act? Because we've agreed that a criminal case has been opened, there's a docket, so it's a subs matter. Now let's come back to crime intelligence, the internal workings. What is it that you say he did not do and should have done? If there's already a criminal case and he was charged internally in terms of the HR processes. So make us understand what you say was not done.
Commissioner Khumalo, before I call you General Khumalo, Commissioner Khumalo, I'm saying is, for a long time, no action was taken against General Lushaba. And when he was arrested in the IDEC matter, and a report was submitted by IDEC to the National Commissioner as we are supposed to do, it was only then that disciplinary steps were taken. The contention is that the moment the head of crime intelligence, and it didn't have to be General Khumalo, the moment the head of crime intelligence had come to understand and appreciate that this is what had happened, this having been the acting divisional commissioner at the time with a different responsibility, internal action to which the disciplinary should have been activated.
Am I correct that that would have been the national commissioner? Because who was the boss above General Lushaba at the time when you say nothing was done?
He acted for I speak under correction, but I think at the time he acted for a very short time.
Yes, but he could not charge himself. So I'm asking who is the person above him who could charge him?
Now you ask me a question.
Is it not the national commissioner?
It should. He was acting for a very short time. And from my recollection, General Khumalo comes back as the divisional commissioner. I'm just not sure where he was in that time. And I'm saying that when it had come to his attention, and this was well before General Lushaba was charged criminally, that action should have been taken.
The way that I've understood the structure, and I'll be corrected if I misunderstood it, is that General Khumalo falls under General Sibiya's. I think General Sibiya is, yes, I see my co-commissioners are nodding. So he's got a boss. According to you, this incident occurs while he's acting divisional head. So General Khumalo is not above him at that point. Somebody else in the position of either General Sibiya or whoever would have been in that position that is occupied by General Sibiya today, substantive position, would have been the person that should discipline him. When you decide to charge General Khumalo as arising from the failure to discipline, why are you not charging General Sibiya as well, or his equivalent? Not only because the incident happened under their watch, and they are the ultimate head of the division or that section, and so finally accountable for what happens. Why are you not charging that person? Why are you not arresting that person?
Again, under correction, there isn't a, I'll check in the charge sheet again, but I do not believe that that is what General Khumalo is charged for. That isn't a contravention that he is charged for.
Remember, you have this overall charge where you say people were placed in these positions. Even in your discussion of this section of paragraph 28, the examples you make, that's why we are mentioning Lushaba so many times. You say because he was not disciplined, he is therefore beholden to General Khumalo, and so General Khumalo, him being the CFO, General Khumalo would be able to access funds through him. Now, if the charge of gratification is indeed a valid charge against any one of them, and with Lushaba you say the gratification is there was no disciplinary action taken against him, and therefore he would have to do something in turn, he must be charged. He must be charged with that offense because he received gratification. It's not just Ms. Mukwele. Whoever he's going to be doing favors for must also be charged because gratification is a two-way street. And so there must be two people charged for this. Whether it's General Khumalo, whether it's his boss, the question remains is you allege gratification, the failure to discipline. You say that is gratification to someone who is strategically placed, who will assist to loot. And I'm saying, well, are you charging anyone with this gratification? You say not General Khumalo. My question is, are you charging anybody? And if you're not charging anybody, my question remains, well, it's a PRECA offense, according to you, to loot crime intelligence funds. Why is no one charged then for that future offense that might happen, might not happen?
I have to come back to you because I've got to go through the charge. I'm not sure that no one is charged,
okay,
or I'm not sure who is charged.
Okay.
But either way, your question, I understand it.
All right. No, so I accept. Go look it up, and then you'll come back and tell us who's being charged with this. But I want to leave it with this proposition that if no one is charged for this, no one at all, one. Two, if whoever was his superior at the time that this incident happened is not charged, and subsequently, why not? But also, it seems it would suggest preferential treatment, that there's no consistency in how you treat offenses. Some you charge for gratification, others you don't. That's where I'm coming from. So when you look it up, prepare that. We'll have the further discussion along those lines.
Okay.
Thank you.
Thank you, Commissioners. Chair, I know my time is not looking good at all, if at all. May I impose 5 minutes literally just to close this topic because I move on to something else next time I start. Thank you. Now, lastly, then, for our purposes today, Advocate Johnson, let's have regard to paragraphs 27 and 26 of your statement, and I take them in reverse order. At 27, you say, when one looks at all the cases referred to IDEC by Mr. Adams, they depict the capture of systems and process for private interest by the head of CI. I take it that's General Khumalo, correct?
Correct.
Okay, and other senior managers. Then you say this too is an issue you intend to testify about. At 26, before that one, you state from second line that if leave to testify is granted, I will get an opportunity to expand on the issues to which reference is made above. And I think that's the exercise we have just tried to undertake, but it's got a second leg to it. You state, I quote, state capture is a type of systemic political corruption in which private interests significantly influence a state's decision-making process to advantage or benefit of certain individuals. Now, in light of what you state at 27, in reference to Mr. Adams's complaint, say the investigations, I'll take it the investigations, not only his complaint, depict the capture of systems and processes for private interest by General Khumalo and other senior managers. I would like you, in 5 minutes, literally, if you can, to explain to the commissioners that the capture of systems and processes for his own private interests by General Khumalo, and relate it to the question of state capture that you reference at your paragraph 26, explaining what relevance that has to the terms of this commission. In 5 minutes, if you can, however briefly you are able to. Thank you.
So having had the discussion we have had in terms of the preceding paragraphs about appointments, suitability of appointments, the placement of individuals, and what that placement would have done is what these paragraphs allude to. But when you go back to the discussion we have had about the policies and the prescripts, it becomes clear that the persons that we thought had been put in certain positions for certain purposes, leaving out the gratification portion, which one must still look at, then that in fact is then not the case.
Then let's look at 27. What about the capture of system and processes for private interest by General Khumalo? Does that remain? Is there evidence that General Khumalo has captured systems and processes for private interests?
That would fall away in terms of the discussion we've had, because a lot of it, in the main, revolved around, and I hate to do this, Commissioner Khumalo, it does revolve around the appointment of Brigadier Mokwele, which we have now dealt with. That was the systems and the capture. Those were the allegations.
So then it would be fair to say we hold these issues in abeyance until you have checked your investigation files and you see if, okay.
Absolutely.
I'm happy to do that.
I must check the evidence.
Yes.
And then come back with a conclusive answer, because what I base it on is in not just the briefings, but that in the briefings, this is the evidence that was presented in the way they present them to the ID. So I would satisfy myself.
All right, I'm happy to flag it until next time. Thank you, Advocate Johnson. Chair, I have a little bit of a crisis in that, yes.
It's not a question. Can I just correct something?
Absolutely, Commissioner.
I suspect that you understood what I was saying when I said if you're unable to find, to give a full explanation why you did not prosecute certain people and others for gratification. That I meant to say it would suggest selective prosecution decision
Understood
and
it.
investigation. You
I
understood
understood it that way.
Thank you.
Advocate Johnson, can I say this? Please keep it in mind for when you come back. My reading of Cracker is that ratification itself is not an offense. It is gratification in order to do something.
Or not
That is
to
the
do.
offense.
Yes.
Because gratification on its own, every time somebody gives you something, I mean, it's gratification, provided, of course, it falls within the definition. But it has to be linked to something that is going to be done, which is improper.
Correct. And or something that is not going to be done in order to benefit.
But there
the
must
person.
be impropriety there. Because
Absolutely.
if something is being done as it should be done,
There's
and
no
it is lawful,
impropriety.
that can be an offense, and people can be charged with that.
Absolutely.
Thank you, Commissioners. Chair, it's obvious.
Yeah, I
we are
almost
not
said
done.
when council said until next time, I thought to myself, is next time not tomorrow? Sorry, we're all tired and one should have a light moment.
No, absolutely no, nothing wrong in that. And I think I share in your hope, but it's just that, a hope. But the reality of the commission is, firstly, I've encroached on others' time. There's a standing program for Friday, so I doubt it will be Friday. But I think the best I can do is to request that Advocate Johnson's further testimony be stood down. As I understand it from the powers that be, I can't have Friday, I can't have tomorrow. It would be a question of to when. Thank you, Chair.
May we see council outside just now? We'll come back when we are ready to. Let's adjourn.
Thank you, Chair.